Hi, everybody, and welcome to our discussion of Chapter 3, which deals with the issue of negotiation in the legal environment of business. You know, when people think about our judicial system and the way that it is designed to resolve disputes, we're usually talking about the adversary process, where I'll get the meanest lawyer and you get the meanest lawyer, and then we'll beat each other to a pulp until we get this matter resolved, or until one side or the other just emotionally wears out or financially wears out. And if you think about it, that's kind of a crazy way to resolve disputes. And so, over the course of the last 50 years or so, we've started to see sort of a movement towards alternative dispute resolution, ADR, which is designed to take some of the I guess the hassle, the expense, and the emotional capital loss out of the dispute resolution process. Most good lawyers that I know, when they are faced with a client who is involved in some sort of a dispute or another, be it a landlord-tenant issue, a divorce, a multi-billion-dollar business dispute, most good attorneys worth their salt should be looking for ways to resolve that issue as soon as they take on that case. The idea that we're going to fight the other side to the death is, I guess, while maybe good for the lawyer's pocketbook, not necessarily good for the client. So, alternative dispute resolution, whether it's used in a formal context or in an informal context, should always be, at least in my opinion, the method of first choice in resolving these matters. So as we can see, the current manner of resolving disputes is based upon the adversarial system. It's a war of attrition, and the issue there is who can outlast the other. Who's going to run out of money first? Who's going to run out of will first to do that? And frankly, if we're involved in a case where the state has accused you of committing a crime and is looking to take away your life, your liberty, or property, then by golly, you would want to fight as hard as possible and until the bitter end. On the other hand, if we're involved in some sort of a divorce or custody matter where children are involved, is that the way we really want to resolve that dispute? As noted, the current manner of resolving disputes is expensive, with lawyer fees being in the neighborhood of $200 to $500 an hour and more in some of the big cities. It's extremely time intensive. If you're looking at getting a dispute resolved in front of a judge, buy several calendars, because it can take a number of years sometimes to get those things completed. And generally speaking, if the judge makes the decision, it leaves the litigants with a bad taste in their mouth. I've talked to any number of judges who will say, if both parties leave the courtroom unhappy, then I know that I've done my job. So generally speaking, we have found that matters that have been negotiated, mediated, or arbitrated, where the parties feel like they've had input into that decision-making process, oftentimes leave the parties feeling a little better about the judicial system than a judge or jury decided case. There's several different kinds of negotiation or alternative dispute resolution that your materials this week talk about. The first of those is what's known as informal negotiation. And again, the lawyers and the parties ought to sort of sit down at the beginning of cases and decide what are the issues here. What can we agree on? What might we be able to agree on, and what are we simply not going to be able to agree on? And so even if you can't resolve the entire case through negotiation, mediation, or arbitration, if you can sort of chunk out the issues that need to be resolved in a contested setting, that sometimes can be helpful, quicker, and or less expensive. So negotiation, again, would just be sort of an informal process of the parties or representatives of the parties sitting down and talking about how might this matter be resolved. There's also what's known as the process of mediation, and mediation is a process whereby the parties will use the assistance of an intermediary or a neutral third party who will try to help the parties come together on some type of a resolution. A mediator is not somebody who hears from both sides and then renders a decision that impacts the parties. Rather, a mediator is somebody who will attempt to bring the parties together to make an agreement on their own. Oftentimes, we see mediation used in the family law context, where folks are fighting over custody of children or property or pension plans or things of that nature. And again, one of the benefits of mediation is that if there is a successful mediation and a successful settlement agreement that's reached out of one, the parties generally feel like they've been actively involved, that they've had their say, and those agreements, particularly in the domestic relations field, tend to stick. You don't see as many parties coming back to court fighting for years over custody or visitation in a mediated agreement. Cases where a judge has sort of rammed a decision down their throats, the same thing cannot be said. Generally speaking, mediation is not binding and it's confidential. In legal world, settlement negotiations are always confidential and inadmissible in a court of law. So, in other words, if you and another party are trying to come to an agreement and you lay all your cards on the table, but an agreement is not reached, information obtained during this negotiation process are not admissible in a court of law. And of course, the reason for that is because we want to encourage settlement rather than litigation. It is confidential. If an agreement is not reached, information obtained during that negotiation cannot be used later in court. And as noted, mediation has proven successful, particularly in family law matters. There's also what's known as arbitration. Arbitration is an alternative dispute resolution that looks a little bit more like what you might think an adversary proceeding looks like, in the sense that there is a neutral, or somebody who is called an arbitrator, who is appointed to basically hear from both sides of the dispute. Many times in business litigation, there are many sides of a dispute that have to be resolved. But this individual actually hears evidence and then renders a decision based upon that. If it's binding arbitration, then that is written up and taken to court, and it has the full effect of a legal judgment that a judge entered. If it's non-binding arbitration, then it may give the parties an idea of what might happen to them if they go to court before a judge. So again, it can be sort of a stick to encourage people to settle. One thing about arbitration is that it has become the preferred method of resolving disputes, particularly in consumer and banking sorts of matters. So if you look at your paperwork that you got when you open up a bank account, or if you've taken out a new credit card of some type, and you read that tiny small print that you get, you will often see that the preferred and oftentimes mandatory means of dispute resolution, if you come to a dispute with your bank or credit card, is arbitration. And of course, what has a lot of consumer groups worried is that that language is not put into those agreements by the banks and the credit card companies because it's necessarily beneficial for the consumers. The concern of the consumer advocate folks, has been that business is well versed in arbitration, that these disputes can be resolved more favorably, more quickly in favor of the business as opposed to the consumer. So in your material this week, you'll read some stuff where that and those issues have been discussed. Arbitration can be particularly useful in very complex business litigation or cases involving things like patents, genetic information, computer technology, and things of that nature, where, think about this. Think about having a jury trial where, litigants are arguing about, scientific discoveries, patent information, genetics, and all that kind of stuff, and the jury is just sitting there making their, $10 a day and wishing they were anyplace else. That might not be a good way to resolve disputes. On the other hand, if you're arbitrator, and again, as you'll see in the text, there's certain training and requirements that folks have to become arbitrators. But if your arbitrator is somebody who is expert in that particular field, then that can be a way where information can be presented much more directly to that individual who will know what you're talking about, and then hopefully the decision that is reached out of arbitration is more sound than might be reached by non-experts hearing that matter. In terms of binding arbitration, which again most consumer agreements have, the decision of the arbitrator is final, and it can only be set aside if the person who is aggrieved by the arbitration can prove that there was corruption, fraud, or undue means used, if there was bias on the part of the arbitrator, if there was substantial prejudice to one party's rights or another. We've still got to be concerned with due process, whether there was overreaching by the arbitrator. In other words, did this arbitrator just clearly favor one side or another and go out of his or her way to ensure a preordained result, or if the arbitration did not result in a final mutual and definite award. In other words, when you look at the binding arbitration agreement, was there something there that one party won, one party lost, one party had to do this, one party had to pay the other some. And again, the problem with using arbitration in these consumer matters is that if you're the holder of a credit card, and you feel like you got into a dispute and got screwed during the process of arbitration, you would have to hire an attorney and go to court to basically overturn that arbitration. And again, that can be extremely time-consuming, expensive, and most folks just don't have the will to do that. All right, well, just a brief discussion of some alternative dispute resolution techniques. The beauty of our court system is that these things continue to change and evolve, and it's always in everybody's best interest to find, well, first of all, not to get into disputes to begin with, but we know that those are going to happen. So if we can find methods to more quickly, efficiently, economically, and I guess most importantly, fairly resolve these disputes in a non-traditional court setting, then why shouldn't we try to do that? All right, well, we'll talk to you again in our next lecture. Have a great day.